You're listening to the GDPR Weekly Show with your host, Keith Budden.
Welcome to this week's episode of the GDPR Weekly Show, and as normal, I'd like to start with a shout out to our new listeners. And this week we have new listeners from London, Preston, Gloucester, Guildford, Twickenham, Slough, Leicester, Hull, Stoke-on-Trent, Reading, Manchester, Coventry, Bournemouth, Derby, Swindon, Bath, Peterborough, Portsmouth, Southampton, Hemel Hempstead, Nottingham and Bristol. And then across on the continent we have new listeners in Denmark, we have new listeners in La Coruña in northern Spain, we have new listeners in Madrid in Spain, Lisbon in Portugal, Oslo in Norway, Vienna in Austria, Tel Aviv in Israel, Bangkok in Thailand. We now have our first listeners in South Korea, so a big welcome to you. And we also have listeners in Queensland in Australia and new listeners in Orlando in Florida in the USA. And that, of course, is on top of all of our listeners right across the world. We're pleased to say we now have listeners in every single continent across the world, which is great. And it's great to all of you to spend half an hour of your week with me catching up on the latest news with GDPR. I really appreciate you taking the time to listen to the GDPR Weekly Show. And I really appreciate your feedback. So please do continue sending your feedback to podcasts at insurety.co.uk. That's ensurety.co.uk. Podcasts at insurety.co.uk. I do read all your feedback and thank you for all the positive feedback. Unfortunately, I don't have time to reply to all the feedback that we receive, but please do send it in. And also any suggestions for things that you'd like to see in future episodes of the GDPR Weekly Show, please send them through to podcasts at insurety.co.uk. And in a few moments, I'll be telling you what's coming up in this week's episode of the GDPR Weekly Show.
Check us out on Facebook.
So coming up in this week's episode of the GDPR Weekly Show, we have an update on the massive data breach at Marriott hotels. We have a look at GDPR and Brexit and what, if any, impact will come from the vote to be held in Parliament on Tuesday. We have some comments about the Epic Games Store. We have some information about GDPR for Pension Trustees and making sure things that trustees there need to be doing. We have a look at how GDPR equivalent rules are spreading around the world, and in particular into Brazil and India. And we also have some news from Europe on an expansion of the areas covered by GDPR. So, as always, a packed programme this week in the GDPR Weekly Show.
You're listening to the GDPR Weekly Show with your host, Keith Budden.
We start with an update on the Marriott data breach. Remember, we spoke last week, in last week's episode of the GDPR Weekly Show, when the news was just breaking of the data breach at Marriott. Well, we now know a bit more about what happened. Basically, the details have been released, or were taken, I should say, of some 327 million guests. And the information included combinations of name, address, phone number, email address, passport number, Starwood preferred guest account information, date of birth, gender, arrival and departure dates, reservation dates, and communication preferences. So, whilst no financial information, obviously a lot of information there, particularly with the passport numbers, which would enable those who've stolen the data to be able to create false identities, to create identity theft effectively on the number of people involved. We've also found out some financial information about Marriott, which is that their turnover in 2017 was £20.4 billion. Put that in context, if the ICO were minded to impose the maximum possible penalty on Marriott, then at 4% of its annual turnover, that means that Marriott would be looking at a fine of £816 million. However, of course, a lot of the guests were from the US. And in the US, actions already started. US Senator Charles Schumer has called on the hotel firm to reimburse everyone affected to allow them to purchase new passports. And 2 US-based law firms are understood to have filed class action lawsuits against the company. So, as well as the EU action being undertaken by the UK ICO and probably other ICOs across Europe, although it's looking like the UK ICO will take the lead on this one. They've also got the legal action, the class actions ongoing in the US. So it'd be very interesting to see over the next few weeks and months how this case against Marriott spills out. But I think it could be a real signpost in the indication of how the regulators are looking to approach these mega breaches of data, because obviously losing data of 327 million people is about as serious as it gets, albeit that I think in Marriott's defence they will argue that there was no financial information taken, which is a plus. But on the minus, as we discussed last week, Marriott took several weeks to report the breach rather than the 72 hours allowed by GDPR. So a really interesting case. We continue to watch it, and we will bring you updates on it in future episodes of the GDPR Weekly Show.
You're listening to the GDPR Weekly Show with your host, Keith Budden.
Obviously, here in the UK, one of the main talking points all week has been Brexit, and like most of the country, we await with interest to see just quite what the reaction of the House of Commons will be when they come to vote on the proposed withdrawal bill on Tuesday evening this week. And we obviously will follow that up more in next week's episode of the GDPR Weekly Show, when we will at least have a pointer in which way, or hopefully have a pointer in which way the UK is heading. But I think it's worth restating something that I think we said in last week's episode of the GDPR Weekly Show. Certainly we've said in the past, but I think it's worth reiterating that whatever the outcome of Brexit, GDPR will continue, because all of the core concepts of GDPR are now embraced within the UK's Data Protection Act 2018. And so just because we're in uncertain times with what's going to happen with our relationship with the European Union, don't think that that means that you don't need to do anything with GDPR, because you do. All the rules of GDPR still apply and will continue to apply after the 29th of March 2019. So please make sure that you are taking action on GDPR and that you are keeping your policies and procedures up to date.
You're listening to the GDPR Weekly Show with your host, Keith Budden.
You may have seen this week that during the Game Awards 2018, a new online game store was announced, the Epic Game Store, which aims to take on Steam by offering numerous exclusive titles. You're probably familiar with Steam if you're an online gamer at all, because many games now are provided via the Steam platform online, and Epic Games, as I say, seeks to be a competitor of them. However, whilst the new game store is attractive to developers in that it's giving developers 88% of the sales profit, which has already begun to attract games like Ashen and Hades away from Steam to Epic Games, it's not all as great as it appears, because the ICO has expressed concerns about Epic Games Store's privacy policy, which do not seem to conform with the laws of GDPR. What the particular areas in question are that several clauses of the Game Store privacy policy say that by agreeing to their privacy policy, you allow Epic Games to temporarily share your personal details with advertisers, and while you can restrict Epic from sharing your personal information, you can only do so in, quotes, limited circumstances, quotes. This goes directly against the spirit and indeed the word of GDPR, because obviously under GDPR, as you will doubtless all know if you're listening to this, that the rights of consumers to protect their data, their personal details, occurs in all cases and not in limited circumstances. Epic Games have tried to cover this off a bit by issuing a statement where they've said that if you are located in the EU, or the Epic entities located in the EU are processing your personal information in the EU, then you have the right to restrict or object to our processing of your personal information. The right to restrict processing arises only in limited circumstances. For example, if you think we are processing inaccurate information. In addition, if we are required to restrict processing but the requirement is temporary, we may not be permanently obligated to adhere to your request. Now, as GDPR practitioners, we have to say that that statement, frankly, is rubbish. Epic Games cannot just say that the only way you can stop them processing is if your data is inaccurate. That's not the spirit or the wording of GDPR. Anyone can withdraw their consent at any time. If you're a regular listener to the GDPR Weekly Show, or indeed you received training from us via our GDPR training course, then you'll know that a consumer can withdraw their consent at any time, and that to withdraw consent has to be as simple as it was to give consent. And also, this in some ways strikes me as similar to the whole thing regarding Brexit at the moment, because again, like here, they've got it the wrong way round. It's not for Epic Games to unilaterally say they don't need to permanently adhere to your request. It's for you. If at some point in the future you decide to give Epic Games Store your permission again, well, that's fine. That's up to you. But it's not up to them to say we'll only stop processing it for a certain period of time. That's not the way it works. And we've also heard of problems with people who purchase via the Epic Games Store getting refunds, but that's outside of the scope of our podcast. So it looks like the Epic Games Store looks like a great idea. I think we'd all welcome some competition to Steam in the game space, but it doesn't seem to have got off to a good start, and I think it's disappointing in a new application which has come to the market since GDPR has come into being, that it's not GDPR compliant from day one. And I think that is, that's bad, really. They should have got much better advice on that. But let's hope they rapidly work to correct that situation and come back soon with a fully GDPR compliant specification and way of working. We will, of course, be keeping an eye on the Epic Games Store, and we'll bring you any updates in future episodes of the GDPR Weekly Show.
Check us out on Facebook.
Just a reminder that as well as the podcast, we now have our own Facebook group. Please do pop along and see us there at https://www.facebook.com/groups/GDPR Weekly Show. That's always one word, GDPR Weekly Show. And do please come and join the group and follow the discussions that are going on.
You're listening to the GDPR Weekly Show with your host, Keith Budden.
We've been doing some work this week with a couple of pension schemes here in the UK. And so I thought it was worth just spending a few minutes on some issues that we found with these pension funds, which I suspect are not distinct to these pension funds and may affect other pension funds or trustees. So if you are yourself a pension trustee, or your company has a pension fund, and I guess most companies in the UK now do, you might wish to pass this part of the broadcast on, or rather recommend that your pension trustees listen to this episode of the GDPR Weekly Show. And obviously if they do have any of these concerns, then they are very welcome to contact us at insurety.co.uk, www.ensurety.co.uk, and we would be very pleased to help any companies with issues. And the specific issues which we found were making sure that there were binding contracts in place between the pension scheme and any data processors that they were using, so that it's important as the pension scheme maintains its role as data controller, but any data processors that they're using or joint data controllers that they're using, it's important that you have a data policy between yourselves and the processors or the joint controllers. Do check that that's in place, and if it's not, then finalising contracts should be a priority for trustees, as unagreed terms between yourselves and your data processors not only pose certain risks, they also open you up to the possibility of sanctions from the Information Commissioner's Office, from the ICO. So do make sure that you've got firm data processing contracts in place with your data processors and or your joint data controllers. The other issue is that pension trusts, in our experience from what we've seen, haven't put enough effort into thinking about how they're going to deal with subject access requests, because a number of pension funds, naturally, because of the length of time which someone may well be a member of the fund, are reliant not just on their modern up-to-date systems of today, but also on a number of legacy systems, and maybe even back to legacy paperwork. And remembering that if someone makes a request for all the information that's held about them, then there's a requirement to use your best endeavours to retrieve as much of that information as possible, and that may mean going into a dusty archive and finding paper documents. It may mean retrieving documents which are perhaps now stored off-site in an off-site archive location, but all that needs to be thought through. And our experience, certainly with the pension funds we've dealt with this week, is that whilst they are well aware of the need to satisfy the requirement, and they can do that via their existing CRM systems, what's not so good is providing all the back information going back maybe 20, 30, 40, even 50 years that someone's been a member of the pension scheme. And it should be remembered that it's the scheme administrators who have a contractual obligation to provide this information, but it's the trustees who have the legal obligation to provide the information, and trustees who will need to answer to the Information Commissioner's Office, to the ICO, if they can't provide that information. And certainly with all the trusts that we've spoken to this week, they've all said that, perhaps unsurprisingly, the volume of subject access requests that they're receiving are spiralling, and I think that's only likely to continue as public knowledge of what's possible under GDPR becomes more widespread, and of course in the way the pensions landscape is changing, and that people now have a lot more options with their personal pensions. So do make sure that you've got procedures in place. Do make sure you've actually documented where all the data is stage one of that. And again, if you need help with any of that, please do get in touch with us, and we'd be delighted to provide you with any assistance you may need in getting that data put together. The third thing is in record keeping, and we don't mean here records in terms of records of your members, but records in terms of decisions you made in how you're handling their data. So do you have all your GDPR policies in place? Have you appointed a DPO? Is your DPO external or internal? Remember, they can be either. For a smaller scheme, it might be more appropriate to have an external DPO. For a larger scheme, you'll probably want an internal DPO, but you may want an external DPO as well. And think as well about how you're starting to plan out audits, so that, because before we know it, it will be 25th of May 2019, it'll be time to do audits, and best way in the world, there aren't enough people with the qualifications to perform GDPR audits all on the same day for every pension fund in the country. So make sure that you book your audit already, and again, we are now already taking bookings for GDPR data audits for 2019. So if you'd like your data audit, please drop us a line to podcasts@insurability.co.uk and we'll get in touch with you and arrange a suitable date. But record keeping is important, and make sure you've got your GDPR policies. Remember that if you've got previous versions of GDPR policies, maybe you've revised them in the 6 months since GDPR came into force, you must keep the previous ones too, because the policy which will be in matter, if there is a problem, will be the policy that was in place at the date that the problem occurred, and not whatever GDPR policy you may have in place now. And the final issue which needs dealing with for pension funds, and this is probably applies to anyone listening to this and not just pension funds, because it's a common misconception that people think that a data breach is just when someone hacks your system, or it's a computer virus, or it's malware. But it's not. It's much more than that. It's about losing a portable device, so losing your mobile phone, or leaving a laptop on the train, or even a USB data stick on the train. It's about genuine human error. It's about putting the wrong pension statement into the wrong envelope and sending it to the wrong person. It's about attaching the wrong pension statement to the wrong email and sending it to the wrong person. It's about CCing in people who have no right to be CC'd in to a particular email. All of those are data breaches. All of them should be entered in your data breach register. Not all of them need reporting to the ICO, and again, this is where you should really liaise with your data protection officer as to when and if you need to report a breach to the ICO. But remember, you do need to record it in your data breach register, whatever, and you have 72 hours from when the breach is discovered or when you become aware of the data breach to do that. And so don't delay. If you discover a data breach of even a very minor nature, make sure you record it in your data breach register. And as always, we'll be coming back to this regularly, I'm sure, in future episodes of the GDPR Weekly Show.
You're listening to the GDPR Weekly Show with your host, Keith Budden.
You'll remember that in a episode of the GDPR Weekly Show a couple of weeks ago, we mentioned about the fact that Japan had now passed some privacy laws which were, to all intents and purposes, exactly the same as GDPR. Well, this is now actually spreading to other states across the world, as we predicted it would. And not only in the US is now the state of California preparing its privacy regulations, which again have a very strong resemblance to GDPR, but privacy regulations very similar to GDPR have now been passed in Brazil and are currently under consideration by the government in India. And so it really does look like this trend, which we suspected might happen, is happening, and that the standards, good standards, adopted as part of GDPR are now becoming more common across the world. And that's something which we as GDPR practitioners, and we think all our customers too, really welcome, because it should make future trade easier if we are all working to a common set of standards as far as data privacy is concerned. Then whatever Brexit and everything else must throw at us in terms of, I don't know, World Trade Organization rules or whatever is coming down the road, at least in terms of data, the more states that adopt GDPR rules, or rules which are 99% the same as GDPR, will make the whole processing of data right across the world a much simpler exercise. And in the long run, that has to be good for companies, it has to be good for organisations, it has to be good for individuals too, because individuals will know that wherever their data is being processed in the world, there are common set of standards are being applied to it. And so I think it's welcome that these spread into more international countries and states is happening, and I for one hope that it continues well into 2019 to spread further around the world.
You're listening to the GDPR Weekly Show with your host, Keith Budden.
In terms of data around the world, the European Data Protection Board, the body which oversees GDPR right across the EU, has issued some guidelines on when data does and doesn't fall under GDPR. And it's interesting that they've actually changed this from the original. You may remember, if you've attended our training or if you've listened to previous episodes of the GDPR Weekly Show, that originally GDPR only applied to data subjects within the EU and the UK and Switzerland. But the European Data Protection Board, the EDPB, have now expanded on this a bit, and they're now saying that processors established in the EU are subject to GDPR even where the processor is processing data on behalf of a non-EU controller that itself is not subject to GDPR. So in practice, that means that an EU processor that processes data on behalf of, let's say, a US entity in connection with US data subjects will still be subject to GDPR for that data. And that's not something that's really been thought through before. So it's not just now if you've got data subjects within the EU, but if the company processing your data is within the EU, then you still need to comply with GDPR, even if you are in the US or elsewhere outside of the EU. So it's broadening the reach of GDPR a bit. And also they now clarify what is a data subject. Data subjects in the Union means any person in the Union whose information is being collected at that moment, regardless of their nationality or legal status. That means that EU citizens and residents are obviously within the scope, but a US tourist using that app in the EU is a data subject of the EU for the purposes of GDPR. The guidelines note that the processing of personal data of EU citizens that takes place outside of the EU will not trigger GDPR so long as the processing is not a specific offer directed at individuals in the EU or to monitor behaviour in the EU. So, for example, a US company with employees in the US who hold EU citizenship will not be subject to GDPR just because they employ EU citizens, but they will if those US employees are actually present in the EU. So it really is coming down much more to where people are actually present as opposed to where they are from. And they also have given more indication of how they're saying whether someone in their opinion, and this is going to apply largely to US companies, whether it's felt that that company has an intention to offer goods and services to people within the EU. And the examples they're giving is that they will establish that there is an intention and therefore the rules fall under GDPR if the company has advertising campaigns in the EU, if they mention addresses or phone numbers within EU countries, if they use a top-level EU domain name, so .eu or .co.uk, .de, .it, .nl, if they have a description of travel instructions from the EU to the service, if it's a service, if they mention customers in the EU, and if they use language or currency commonly used in the EU, and whether goods are delivered in EU countries. So, to take an example, if you have a US company which at the moment does not have any EU or UK customers, but it has products on its website priced in pounds sterling or in euros, then GDPR applies to the data of that company, even though at this moment in time they do not have any EU customers. And that is a big change in the breadth of application of GDPR. And so for those of you who are listening in the US, do be aware of this. The other thing which the EDPB, the European Data Protection Board have tightened up on is in their definition that if you are processing data for people in the EU, or you are now under these new rules considered to be attempting to deal with people in the EU, then you must have an EU representative. You must have someone within the EU who acts on your behalf to liaise between yourself and the ICO. And quick advert here, that is this new service which we are offering. So if you are listening to this in the US and you need an EU representative for the purposes of GDPR, then please do get in touch with us. It's a very simple process to set up, and we can act as your EU representative for you and satisfy that requirement of GDPR. And of course, if you've not done anything towards GDPR, which you may not have done in the past, we can guide you through the steps you need to take. And I know we do have quite a number of listeners in the US, so please do get in touch with us about that. If you have any questions, please send any questions to podcasts@Ensurety, that's ENSURETY.co.uk, or you can send them direct to myself, your host, Keith Spudden, at Keith, KEITH, @Ensurety.co.uk.
You're listening to the GDPR Weekly Show with your host, Keith Budden.
So that brings us to the end of this week's episode of the GDPR Weekly Show. I hope you found it useful. I hope you found it entertaining. Please do let me know. Let me have your feedback by sending an email to podcast@ensurety.co.uk. You can find out more about us at Ensurety at www.ensurety.co.uk. And I look forward to speaking to you again, same time, same place, next week. Have a good week, everybody, and remember to keep your data safe.
Check us out on Facebook.
The GDPR Weekly Show is an Ensurety production. Follow us on Facebook at www.facebook.com/Ensurety.